Hi, and thanks for joining us again. Today, we're going to start the series of HIPAA trainings. Again, just like the OSHA trainings, the HIPAA trainings will compile of about 10 to 12 different trainings on different subjects, HIPAA related. And your staff should be reviewing these trainings yearly to make sure that it is fresh in their mind and they're keeping up to date with them. So feel free to share this video with your staff. It's going to go by pretty quickly. Feel free to do a screenshot if you need to print something out for your staff. Give me some feedback if you would like other topics for us to cover. Let's get started. We call this one HIPAA 101. So HIPAA rule standards, there are the privacy rule, which protects the privacy of the individual's identifiable health information, the security rule, which sets the national standards for security of electronic protected health information, and the breach notification rule, which requires covered entities and business associates to provide notification following a secured protected health information. This would be similar to those alerts we're always getting from our email or vendors that say, hey, there was a breach and your information was shared and this is what was shared. So what is protected health information, or otherwise known as PHI? It is individually identifiable information. As an example, a name with an address or a social security number or a date of birth, and it can to identify that patient. And it relates to the health care or health conditions of that particular patient. It can be transmitted or maintained in electronic, or other format or medium. What is a covered entity? A covered entity includes a health plan, a health clearinghouse, and all of us as healthcare providers who transmit health information in electronic form in connection with a transaction, such as a claim submission. Covered entities also work with business associates. A person who, on behalf of that covered entity, performs a function or an activity involving the use of disclosure of PHI. For example, whoever is processing your claims, somebody in your accounting department, part of your management company, your administrative people, legal services, copy services. These would all be considered business associates if they are not part of your actual core company. So business associates have to sign a BAA, a business associate agreement with the covered entity. So that BAA, that business associate must bind its subcontractors to a similar business associate. So if you contract your claims out to somebody and they subcontract to a medical records copy service, they have to bind that subcontract well. When can PHI be disclosed? Of course, it can always be disclosed to the individual. You must permit your patient to view his or her records during regular business within 5 working days after the receipt of the written request. Paper copies are to be provided within 15 days of request. You can also disclose this information when it comes to treatment of the patient or payment of the services rendered or other general operations in order to take care of that patient's care. So an example, doctor to doctor is okay to share the information if you are both managing this patient's care. A primary care doctor refers the patient to the specialist. The specialist is able to give that information on that patient back to the primary care doctor. It's for claim submission, quality assessment, and improvement activities. These are all okay times to disclose the PHI. Now, when you have the individual's permission, you can also disclose the PHI, but it's going to be by written request to a third party, like an employer or a life insurance company, and the individual is allowed to restrict what might otherwise be permitted to health plans if they pay for a service out of pocket. So, in other words, if a patient decides, I'm going to have a special visit today, but I'm going to pay cash for this visit, I'm not going to use my health insurance for this visit. If the health plan is requesting records, the patient is allowed to exclude that visit from those records that are released to the health plan. Minimum necessary need to know. Why is this important? At all times, when you are working with protected health information, you should always only give the minimum necessary or what they need to know. Nothing more than that. So, just give what is needed. And I'll kind of hold here so you can, I'm not going to read the whole slide for you, but do not ever give all of the information if they do not need the information. And limit access only to those people who need access to the information to accomplish the use or disclosure. Don't let everybody in your office have access to the medical information. Minimum necessary principle does apply to this partial list, okay? Claims and billing, attorneys, insurances, disability, benchmarking reports, financial analysis, accreditation and licensure, credentialing, education and training, and research. Minimum necessary principle does not apply to direct treatment situations when you are in communication with another professional who's treating that patient. They need to have a full picture of who they're treating and how they're treating them. Disclosing medical information to the patient himself or herself, you do not have to do the minimum necessary. It is their information and they have the right to it. And disclosing information authorized to release by the patient. Certain disclosures are required by law. Security rule basics. This applies to electronic health, protected health information, as you will hear EPHI. And it requires that entities maintain the appropriate administrative, physical, and technical safeguards that are going to protect the patient's health information. In other words, for administrative, are there policies in place regarding logging in and out, regarding backing up data, regarding anything that staff would need to do? Physical rules, such as media controls. Don't put anything on a thumb drive. Don't remove thumb drives from the office. Don't give people access to server rooms that are not supposed to be there. And technical, of course, making sure that every person has a unique password. Passwords are never to be shared, and that there's encryption put in place, and there are automatic log off measures on your systems so that if somebody walks away, nobody can walk up and get access to information under somebody else's name. Let's talk about password guidelines because this is a tricky one. It's very easy for the use of day to day, people want to save their passwords. You should never save your passwords on a computer. So the user must select a password conforming to the following guidelines. The password should be between 8 to 10 characters, if not more. Passwords should not be the name of a pet, a spouse, a child, a parent. These are too easy for people to guess. Passwords should not be a word or sequence of letters and numbers that the user can remember. Sorry, passwords should be a word or sequence of letters and numbers that the user can remember, but could not easily be guessed by even a close friend of the user. Passwords should never be written down, and your password should never be given to other staff members. Best case scenario, a new password should be selected every 90 days, and current or previous passwords should not be reused. That's not to say if your password is Apple Beta Dog, that you can't change it to Dog Apple Beta, but you should reuse the same password. Security rule basics requires a thorough risk assessment. This is for our purposes. If you are an Argus or Pro Health office, we have a 10-page checklist of all of the security measures that have to be reviewed annually. This is not a one size fits all. You have to take into account the organization's technical infrastructure, their finances, etc. But the important thing is to have done a risk assessment and identified any weak points and followed through with the recommendations. Breach notification. These are the basics. Relevant for unsecured PHI only. Unsecured is not encrypted. Also, only relevant when there has been a breach. A breach is non-permitted acquisition, access, or use of unsecured protected health information that compromises the security and the privacy of the information. All breaches should be reported to your privacy officer. In our case, that would be Peachy Paulino, and you can either email compliance@prohealthpartners.com or call the number listed below. If you are not an Argus or ProHealth office, you need to find out from your company who is your designated privacy officer. To determine if a breach has occurred, we must first examine the risk factors. Nature and extent of PHI involved, including the ability to re-identify unauthorized persons to whom disclosure was made or who used the PHI, whether the PHI was actually acquired or viewed, extent to which risk to PHI has been mitigated. These are all factors that we need to keep in mind when we are identifying a breach. An example, an accidental fax to the wrong physician's office with the recipient destroying the fax, that is not a breach. There was no notification required. Now, on the other hand, a lost laptop or thumb drive is probably a breach, and notification will be required. Breach notification rule. You have to notify the individual. In cases where there are more than 500 individuals, you have to notify the Secretary of HHS. And also in cases with less than 500 breaches within 60 days of the end of the current calendar year, and to the media in cases of over 500 breaches. It's a lot of work when there's a breach involved. But there's actual penalties. So here are the different HIPAA violation penalty tiers. And I'll go ahead and take a screenshot. I'm not going to read every one of these, but this can get very serious and very costly. Not to mention, we have to always keep in mind the patient's privacy. Now, there are criminal penalties. And here are the criminal penalties. Covered entities or individuals who knowingly or with reasonable cause to obtain or disclose individual identifiable health information. The penalty is up to 1 year of a potential jail sentence and up to a $50,000. That's huge. Offenses committed under false pretenses, the penalty is up to 5 years jail sentence and up to plus $100,000 fine. And then offenses committed with intent to sell, transfer, or the use of personal gain or malicious reasons, the penalty is up to 10 years of a potential jail sentence plus $250,000 fine. And here is the website if you would like to get more information. But that is all that I am going to cover today. So I appreciate you taking the time to listen, share this video with your staff. This is again HIPAA 101. It is the very basics, and we will do additional videos after this.